seated.
Good morning, Your Honor.
Good morning, Ms. Meltzer. Very good to see you.
Good morning. It is a pleasure to appear in front of you for the first time. Evelyn Meltzer of Troutman, Pepper, Hamilton, and Sanders, counsel to the Christmas Tree Shops and its affiliated debtors. As an initial matter, Your Honor, we want to thank you and your staff for quickly coming up to speed on this case and making time to hear our first day hearings today. We truly appreciate it. We also want to thank the U.S. trustee, Mr. Hackman, for all of his help over the weekend and these past few days as we work together to resolve the issues regarding the first day motions. And I am pleased to report that we have resolved all of our issues with the U.S. trustee. Just one thing to note, the U.S. trustee will be making a statement with respect to the cash management motion.
And that's become something that we do at every
standard
first day hearing.
Correct,
yeah.
Your Honor. Additionally, Your Honor, by way of introduction, I want to introduce my team, my co-counsel from Murphy and King, Harry Murphy and Chris Condon, and additionally Leah O'Farrell, who is listening on the phone today and was instrumental in helping us get ready for these hearings. Additionally, Your Honor, my colleague, Marcy McLaughlin-Smith, as well as our first day declarant, Marc Salkovitz, who is the executive chairman of the Christmas Tree Shops and Handle Holdings, as well as the chief executive officer of the Salkovitz Family Trust, Handle LLC, and Nantucket Distributing Company, which are the 5 debtors in this case.
Great. Welcome, Mr. Salkovitz.
Just a few housekeeping matters before we move to the background and the items that are scheduled for today. Your Honor, we will be filing after the hearing the revised proposed orders under certification of counsel and uploading them. Additionally, since this hearing is hybrid and there may be people listening by Zoom who don't have copies of the black lines, I did want to put on the record now how they can get them. So if you need the black lines, please email cynthia.vernon@troutman.com. And I'll say that again, Cynthia, Cynthia@Troutman, TROUTMAN.com. And finally, Your Honor, I did want to note that the way we plan to move forward today, if it's acceptable to Your Honor, is Mr. Murray is going to provide a background, move the declarations into evidence. Mr. Clark has asked to make a couple statements as well after that, and then we will turn to the agenda.
Okay. I have one question for you before you get going. I'm happy to hear that you worked out all the comments that you had from the United States trustee. Do you anticipate that there will be any objection or any other issues from any other parties today?
No, Your Honor. I think we've worked out everything for today, although I do believe that one of the parties has some comments to the cash management and maybe another order or two that I think we may have missed a comment or two that we're just going to put some statements on the record as we work our way through those orders.
Okay.
But I don't think that there is anything contested today.
Okay. Okay. That's great.
Thank you, Your Honor. With that, I'll turn it over to Mr. Murray.
Thank you, Ms. Meltzer, and thank you, Your Honor, and echo Ms. Meltzer's comments about the accommodations of the court, the U.S. trustee, and all the parties in interest to respond quickly to a fast-moving case. And literally and truly, Your Honor, this is going to be our goal here is to reorganize and not to liquidate, Your Honor. And we're grateful for the support that we've seen to date from the parties in interest in the case to accommodate the effort of the company to reorganize. Your Honor, just a way of background, as Ms. Meltzer points out, there are 5 debtors. Effectively, the only operating debtors is the Christmas Tree Shops LLC. For the record, the other 2 handle entities that are debtors are holding companies, direct and indirect holding companies of the Christmas Tree Shop. Salkovitz Realty Family Trust at one point owned the corporate real estate, but which utilized by Christmas Tree Shops as a distribution and warehouse in Middleborough, Massachusetts. That property was sold in February of 2023, and the proceeds were utilized to pay down the secured debt, primarily sold, and I'll get into that a little bit. So that doesn't have any assets as we're aware of, but it remains an obligation, an obligor under the borrowings that the subject matter of the pre-petition loans and the DIP loans. There are no assets that we're aware of, but there are those liabilities. The Nantucket Distributing is also not a non-operating entity. It's not it was originally formed prior to Mr. Salkovitz and his wife's acquisition of the Christmas tree shop, and it's an importing company just to clear product through customs. It doesn't purchase product from Asian, primarily the product is coming from Asia. It doesn't purchase that product. It merely facilitates the import and clearance of those goods from first the Chinese ports, then the U.S. ports, Your Honor. There's no employees of that entity, Your Honor. So this is all about the Christmas tree shops, Your Honor. Just a way of background, Your Honor, and this will be set forth in the first day affidavits. The debtor operates 82 stores in 20 states, employs approximately 3,000 employees, approximately about 1,000 of which are full-time employees. Last year, it did approximately $500 million in sales. The debtor has, I think, the most stores in Massachusetts, 15, and between Delaware, New Jersey, and Pennsylvania, there's 19 stores. Up and down the East Coast, some in the Midwest, and some in the South, Your Honor, in Florida and the like. Except for the 10 stores and perhaps one or two other underperforming stores, we intend to try to reorganize around that core group of stores somewhere in the 70-store range going forward, Your Honor.
Mr. Murphy, in the first day declarations, Mr. Salkovitz talked about the effect of he talked about the fact that Bed Bath & Beyond has rejected some of the leases. How is that going to affect your plans? Do any of those overlap with the closing stores, or are you negotiating with landlords to enter into new leases on those?
A little bit of both, Your Honor. Certainly, as to the GOB, or the request to conduct store closing sales, one of those is a Bed Bath & Beyond sublease situation. The remaining stores is the second point, Your Honor. We either have or are working to get a direct lease with the landlord on those locations. Mr. Salkovitz and his team, I think, is making progress on those, and we're hopeful we'll be able to obtain direct leases to the extent we don't have direct leases, Your Honor.
Good, thank you.
As I said, noted, Your Honor, Christmas tree shops certainly in New England and Massachusetts, we see them often. Generally, they're 30,000 square feet or so stores, generally freestanding. There are a few located in malls, but generally they're almost a destination, Your Honor. I'm not a big shopper, but I kind of recall a case that I have received more comments from my wife's friends, my family about, oh no, is the Christmas tree shops going out of business? Mr. Salkovitz says it's a unique shopping experience, one that I haven't experienced, but I think I'm going to at some point, Your Honor.
Well, we in Chambers are all familiar with the Christmas tree shop. We have one a few miles from here, and we're happy that it's going to be staying open. Yeah,
and one in the Cape, and one in the Sagamore Bridge to Cape Cod, which I've probably for the last 50 years have seen as going by with the big thatched roof, and it is truly a destination store. It was really formed in 1950, Your Honor, and has obviously grown considerably, acquired by Bed Bath & Beyond, and then ultimately acquired by Mr. and Mrs. Salkovitz in 2020 for $137 million, Your Honor. And that included the purchase of the real estate and the business, Your Honor. So there was a considerable investment price paid for this, and the business did quite well in the first year or two post-acquisition, particularly in 2021. Again, you've seen it, Your Honor, in the first year of the pandemic, first full year of the pandemic, people were very actively buying retail and the like, and the company generated a positive EBITDA of approximately $16 million. 2022 was a different story. The retail traffic diminished, the basket size, as I've come to learn the term, decreased substantially, and the company suffered approximately in excess of $40 million negative EBITDA last year. In connection with that, in the fall of 2022, the company determined to raise capital to pay down debt, secured debt, principally through the sale of the distribution center. And ultimately that was sold in February of 2023 for $105 million, 90+ million of which went to pay down secured debt, $7 million of which went to secure a letter of credit because it was a sale leaseback whereby Christmas tree shops needed to put up a letter of credit to secure as part of the sale leaseback transaction. And the miscellaneous remaining funds were used to pay closing costs. I think CTS ultimately ended up, Christmas tree shops ended up with approximately $2.5 million to additional working capital. As a consequence, going into this year, following the sale, was hoped that maybe we could do an out-of-court composition with creditors, work with them, obtain additional financing from the lenders, but frankly, liquidity and creditor pressure, Your Honor, because the company's unsecured debt approaches $80 million, necessitated the filing. And this was a relatively rapid development where the company actually began the consideration of a filing in the middle of April, Your Honor, and we've been mobilized to get up to speed and get pleadings filed, and most importantly, negotiating an agreement and support from our principal lenders. And the principal lenders, Your Honor, at the time of the filing are Eclipse and Hilco, which share our ABL facility, which a balance of approximately $26 million at the time of the filing. In addition, there's a lender represented Pathlight that is owed about $16 million. So we have about $42 million for secured debt on the company, but we think there's substantial value in the company beyond that, Your Honor. And but we need to come up with a plan to address our pre-petition liabilities. In terms of doing so, what we're wrestling with, Your Honor, is the 365 limitations of 210 days, which the lenders support and cognizant of the fact that if we're unsuccessful in the reorganization, we may be going out of business sale. So we've aggressed, as part of the financing, Your Honor, we've agreed to and committed to getting this done within 117 days. And that's going to require very quick action and support from not only the secured lenders, the unsecured creditors, our landlords, our vendors, our customers, where we believe since the filing, sales have exceeded expectations by 30%. Crazy what the publicity does, but people believe in the stores, they like the stores, and we hope that we're able to keep the stores full. And in today's motion is all about doing that. It's keeping the stores full. It's the $45 million of DIP financing that we're seeking approval for on an interim basis. It's the approval of the consignment relationship by which we Restore, an affiliate of Hilco, provides $20 million of goods on a revolving basis by which we pay them weekly for the sales for the previous week. And as I told Mr. Hackman from the U.S. Trustee's office this morning, perhaps I should have been more expansive in the pleadings to explain how important that is. We have about $60 million of inventory in the stores, Your Honor, and about $20 million of that is on the consignment relationship. And these are fast-moving goods. We're turning those goods about every 60 days. And for every $2 million of goods that we sell, we make about $750,000 a week. So this is real important inventory that we need to continue to have flow in the stores. So through all that, and certainly with the help of Ms. Meltzer and her team, we've been able to get here today, and I think the first days are resolved. And before we get to those, Your Honor, I think some of the creditors would like to introduce themselves to the court, Your Honor.
That'll be fine. Mr. Clark, good to see you.
Judge, good morning. It is a true pleasure to appear in your courtroom for the very first time. Congratulations or condolences on ascending to the bench.
Thank you.
For the record, Tony Clark of Greenberg Traurig, along with my corporate colleague Leo Munchnick for Eclipse Capital, administrative agent and lender into the DIP facility, and pre-petition secured revolver agent and lender. With the court's permission, Mr. Munchnick, who is much more knowledgeable than me about the details here and has been involved longer than I have, may weigh in on several of the motions pending. Most importantly, the DIP motion. We'll get a Pro Hoc Vice motion on file for him promptly. But on the DIP motion, as you've heard from Mr. Murphy, the U.S. trustee had extensive comments on the DIP order, which after discussion among the debtors, the lenders, and the United States trustee have been resolved, and Mr. Munchnick can review those items in detail and respond to any questions the court might have when we get to that on the agenda. But more generally, the Eclipse secured lenders want to say that they fully support, obviously, the DIP motion, and they support the debtors and their management in their efforts to effect a reorganization here. But to be candid, the Eclipse lenders, they've been involved with the debtors for several years and have a duty here to protect the interests of their own investors and stakeholders. And these lenders, Your Honor, candidly have some skepticism about the prospects for reorganization here, and therefore have required the terms reflected in the DIP financing documents. We believe that the DIP facility provides the debtors with a reasonable opportunity and chance to reorganize, but the facility does have appropriate guardrails in the budget of the milestones to protect the lender's fully secured position. So we intend to pay very close attention to the debtor's progress as we move through these cases. One last comment, and then I'll sit down. We did see mentioned in the first day papers mention of some insider intercompany debt. We've asked for the relevant documentation on those debts, those obligations. But for the record, we reserve Eclipse's rights with respect to those issues. Thank you very much, Your Honor.
Thank you, Mr. Clark. Does anybody else wish to be heard at this point?
Your Honor, again, Evelyn.
I'm sorry.
Your Honor,
Can you step to the podium, please?
just for purposes of introduction, Your Honor, Stephen Fox from Reamer and Bronstein on behalf of Pathlight Capital LP as the pre-petition term loan agent. Your Honor, I long ago learned as a young associate appearing before the court that say nothing in an unopposed hearing. So, Your Honor, I'll reserve comments as we go through the motions, but thank you. It's a pleasure to appear today.
It's good to have you here, Mr. Fox.
Your Honor, I know we emailed all the black lines to the court, but I wasn't sure if it would be easy if I handed you a set as well.
I've got them handy.
Okay,
So that's
thank you,
fine.
Your Honor.
I'm hearing somebody else. Does somebody wish to be heard? Okay, I'm going to instruct everybody who's appearing by Zoom to keep themselves on mute unless they're addressing the court. Mr. Murphy, I do have some questions about the business. I'd like to just understand a little better
Absolutely.
how things are working. In one of the declarations, Mr. Salkovitz described that typically you have 30,000 SKUs, but that there's also been a diminution in available inventory because of the constraints that the company has. So how many SKUs are you running now?
I thought it was 30. Oh, right now, Your Honor, what we normally would like to like, if I may.
If Mr. Salkovitz wants to step up,
Your Honor,
that's
if I
just
may.
fine.
Your Honor, we have about 17 to 18,000 active SKUs right now, less than we typically have.
Right.
We have a little bit more depth than breadth, which is affecting our business.
Got you. And I'm wondering too about sort of how the business works in terms of planning its buying and sort of where are you now in the buying cycle? For instance, are you looking at Christmas inventory now, or are we talking Thanksgiving? Or
We're talking Christmas right now.
Okay.
That would go on the water in August.
okay, and is that sort of typical lead time, 7 or 8 months ahead for each season?
That's normal, very
Okay.
normal.
Okay, and most of the inventory is coming from abroad? Is
For
that right?
Christmas, yes. For most of our seasonal goods come from different parts of Asia.
Okay, okay. No, I appreciate that, Mr. Salkovitz.
Sure. Thank you.
Your Honor, in connection with the first days, I'd like to introduce the affidavit, move to introduce the affidavit and a mission of the affidavits. I think it's at docket number 12 and 23, Mr. Salkowitz's affidavit and supplemental affidavit, and the affidavit of KCC, Mr. Evan Gershbein, I believe, and I apologize if I got that wrong. It's at docket number 5 and 44, Your Honor, in support of the first day motions.
Does anybody object to the admission of Mr. Salkovitz's declarations exclusively for the purpose of today's hearing? Mr. Clark.
No objection, exclusively for the purposes of today's hearing. Thank you, Your Honor.
Thank you. Anybody else? Okay, I hear no response that Mr. Salkovitz's declarations are admitted. Does anyone plan to cross-examine Mr. Salkovitz? Okay, I hear no response. Does anybody object to the admission of Mr. Gershbein's declaration? Okay, again, I hear no response. And does anybody wish to cross-examine Mr. Gershbein? Once again, I hear no response. The declaration, Mr. Gershbein, is admitted.
Thank you, Your Honor. And just as a matter of housekeeping, Ms. McLaughlin-Smith will address, if you may, Your Honor, office number 12 on the agenda, the store closing motion. She's been responsible and indispensable in working through those issues with any number of parties in interest. And we appreciate her efforts, Your Honor. There's been some long nights by her and her colleagues. Your Honor, the motions, I think the first one is a relatively, as I understand, procedural in nature, and we're not aware that the U.S. trustee or anyone or other parties in interest has any issue with it. So for entry of an order authorizing joint administration of the Chapter 11 cases, Your Honor.
Does anybody wish to be heard on joint administration? Yeah, I hear no response. This is a routine motion in cases where there are multiple debtors, and under Local Rule 10,015-1, I have authority to order this relief. So based upon the evidence before me in the form of Mr. Salkovitz's declaration, I find the relief is warranted and will ease the administrative burden for the parties and the court, and will enter the order. I have one sort of universal comment to make, and it's been addressed in the revised order that Ms. Meltzer provided to Chambers. In paragraph 6, we struck the word exclusive, referring to the court's exclusive jurisdiction.
Yes, Your Honor.
And across the board, my view on this is no different from my colleagues. I don't believe that the bankruptcy court's jurisdiction is exclusive in any of the matters that are before me today. So as we upload the orders, if we could strike the phrase exclusive jurisdiction and just say we retain jurisdiction, I'd appreciate it.
It's been done in all of the orders already.
Wonderful. Thank you very much, Ms. Meltzer.
Thank you, Your Honor. The next motion, Your Honor, is a motion for, I think, again, procedural. I'm not aware of any comments or opposition to the motion regarding the redaction from the creditors matrix, personal identifiable information in granting related relief, Your Honor.
Okay. Does anybody wish to be heard on the creditor matrix motion? Okay, I hear no response. I note that I reviewed the revised order that Ms. Meltzer sent over to our chambers. Again, this is relief that's fairly standard in this jurisdiction, and I believe that the order as proposed balances the public nature of the proceedings against the consideration of public information being made publicly available. So I'm satisfied that based upon the record before me, the relief is warranted and appropriate, and I will enter the order. I made one comment to myself on the order, and it's just a typographical error. At paragraph 1, it recites as drafted, the motion is granted on as set forth herein. So if you just want to strike the word on, then go ahead and enter that order.
Yes, Your Honor. Got it. Thank you, Your Honor. Your Honor, the next motion is authorization to retain Kurtzman Carson Consultants, LLC, as claims and noticing agents effective as of the petition date. And I know they've been working hard to get notice out in connection with the filing and in today's proceedings, Your Honor. I think Your Honor has already admitted in support of that the declaration of Mr. Gershbein. And unless Your Honor has any questions, I'd ask that motion to be allowed.
Does anybody wish to be heard regarding KCC's retention? Okay, I hear no response. The KCC is going to be performing a function that's required under Local Rule 2002-1, and I found that the engagement letter as modified by the proposed order complies with all local rules, as does the order itself. So I'm going to go ahead and grant that motion. I would ask for one revision to the order, though. In the revised version that I've reviewed, the phrase indemnified a parties appears, but it isn't defined in the order. It actually doesn't appear in the application itself. It is defined in the engagement letter. So I just ask that for the purposes of clarity, where the phrase identified parties first appears, that you put in a parenthetical or something of the sort saying as defined in the engagement letter, or however that document is defined. Okay, thank you very much.
Thank you. Next, Your docket, I believe it's agenda item 6, Your Honor, is debtor's motion for entry of interim and final orders authorizing but not directing the debtors to continue using their existing cash management system, including maintenance of existing bank accounts, checks and business forms, honor certain pre-petition obligations, and continue to perform intercompany transactions, granting administrative expense status to intercompany claims, and granting related relief. I do believe we have a comment from counsel on this motion, Your Honor, but other than that comment, I'm not aware there's any opposition.
Well, let me hear first from Eclipse. Yes, sir.
Good morning, Your Honor. Leo Muchik on behalf of Eclipse. So the comment was, there are two comments. First, just to clarify that the pre-petition cash management procedures, including the sweeping of the accounts, is going to happen on a post-petition basis under the DIP, and that's not being interrupted. And the second one is with respect to the intercompany claims and transactions, that the first, no pre-petition amounts will be paid. Second, that these should be book entries and not really no cash disbursements outside of CTS. And finally, that the intercompany claims or transactions do not include the descriptions of the loans that my colleague mentioned earlier between Salkovitz Trust, co-lending the money under agreements that are co-borrowing agreements.
Okay. Are you asking for revisions to the order or a representation on the record?
A representation on the record. We'll pick it up on the final order when we get there.
Okay. Mr. Murphy?
Yes, Your Honor. For the record,
Thank you.
we have no problem to agree to those issues.
Okay. Does anybody else wish to be heard regarding cash management? Mr. Hackman. Good morning, sir.
Good morning, Your Honor. May it please the Court, Ben Hackman for the U.S. Trustee. It's a pleasure to appear before Your Honor for the first time.
I'm delighted to have you here, Mr. Hackman.
As counsel indicated, all of our comments are resolved on these motions before Your Honor today, and I thank counsel for working with us on them. I did want to put a brief statement on the record about cash management, which is Section 345 obligates debtors in possession to require from an entity with which estate monies are invested, 1, a bond having features defined in Code Section 345B, or alternatively 2, the deposit of securities consistent with 31 U.S.C. Section 9303, unless the court orders otherwise. In connection with the cash management motion, we make 5 observations. First, Section 345 places an obligation on the debtor in possession to require protection for its monies from the institutions which hold such monies. Second, while Section 345 does not mention the United States Trustee's Office, the office in its supervisory role, pursuant to 28 U.S.C. Section 586, assists with protection of debtor in possession funds by entry into uniform depository agreements, or UDAs. UDAs obligate depositories to maintain collateral for bankruptcy funds on deposit in an amount no less than 115% of debtor in possession and trustee deposits which exceed FDIC insurance limits. The United States Trustee maintains information on the banks who have executed UDAs, regularly provides this list to debtors' advisors, and is working to post a current list to its website. Third, in order for a debtor in possession to comply with Section 345 where a UDA bank is involved, the debtor in possession must first identify and disclose all of its depository accounts where monies are held, and second, contact those banks to ensure that the relevant accounts are designated as debtor in possession accounts. If the debtor in possession does not identify all of its accounts and take steps to ensure that its accounts are properly designated, then the bank will not treat such accounts as debtor in possession accounts. Fourth, the monthly operating report filed with the court requires that bank statements and bank reconciliations for the reporting period be attached. Periodic reporting assists the U.S. Trustee's Office with ensuring that operation of the debtor's cash management system is consistent with the court's authorization, and as well that deposits remain in authorized depositories where estate funds are appropriately collateralized or maintained in accordance with Section 345. And then fifth, recent bank failures highlight the importance of the debtor in possession's compliance with Section 345 for the benefit of its stakeholders. The United States trustee seeks specific language in any interim cash management order that identifies concrete steps and a definite time frame to achieve compliance with Section 345. The United States trustee encourages the debtors to act promptly to ensure full compliance with Section 345 and reserves the right to be heard on the cash management motion at the final hearing.
Thank you, Mr. Hackman.
Thank you, Your Honor.
Does anybody else wish to be heard? Mr. Fox.
Thank you, Your Honor. With the debtor's representations in response to Mr. Munchnick's comments, we will have no opposition to the motion. Pathlight does hold a lien on the accounts and the cash and cash equivalents that are deposited in those accounts. And we are also the counterparty to various deposit account control agreements covering those accounts. So we support the motion, entry of an order. We have asked Debtors Counsel when they upload the order to ensure that paragraph 2 of the order is revised to include Pathlight's counsel as a notice party for timely receipt of objections, and they've agreed to do that.
Thank you, Mr. Fox. Does anybody else wish to be heard regarding cash management? Okay, I hear no response. Based upon the evidentiary record before me, I find that the relief is warranted and appropriate, and I'm going to enter the order. I'd note that the debtors are seeking interim relief here, and under Rule 6003B, I would be precluded from entering this order unless the debtors have shown that there would be immediate and irreparable harm if I did not enter the order. Based upon the evidence before me, I do find that the relief requested in the motion is necessary to avoid immediate and irreparable harm, and therefore I will enter the order on an interim basis.
Thank you, Your Honor. Your Honor, item 7 on the agenda is the debtor's motion for entry of interim and final orders authorizing the debtors to maintain and administer their existing customer programs and honor certain pre-petition obligations related thereto and granting related relief, Your Honor. And this is, as Your Honor knows, is critical to any retailer, business, or for that matter, any Chapter 11 debtors to maintain the goodwill of its customers, that the obligations that it has to those customers maintained during the course of the Chapter 11. It's Mr. Salkovitz here in accordance with his affidavit, Your Honor, and I think it's self-evident that if we don't honor those programs, that business would be subject to immediate and irreparable harm. So we'd ask that motion to be approved.
Does anybody wish to be heard regarding the customer programs? Okay, I hear no response. I'm going to grant the motion. I agree with you that this is necessary relief, particularly if the debtor is going to be able to reorganize. And so I do find that the relief requested is appropriate and warranted. Again, this is an interim order, and I do find that immediate and irreparable harm would result to the debtors if I did not enter the order today on an interim basis, and therefore I will do so.
Thank you, Your Honor. Item 8, Your Honor, is the motion for debtors for interim and final orders authorizing the payment of pre-petition insurance obligations and immediate post-petition insurance obligations and granting related relief. Again, Your Honor, the maintenance of insurance is an obligation of any business, including debtors in possession, and any failure to pay and honor those authorizing the payment will jeopardize that insurance coverage, expose the debtor and its estates to risk, and also third parties to risk for uncompensated harm or damages that might arise from the failure of the debtor to maintain appropriate insurance. And we submit that immediate and irreparable harm would be suffered if that should occur. So we would request that this motion be allowed, Your Honor.
Does anybody wish to be heard on the insurance motion? Okay, I hear no response. Based on the evidence before me, I find that the relief requested in the insurance motion is appropriate and warranted, and I will enter the order. Again, this is on an interim basis, and I do find that immediate and irreparable harm would result if I did not enter the order today. So therefore, I am entering the order on an interim basis.
Thank you, Your Honor. Item 9 on the agenda is emergency motion for interim final orders authorizing debtors to pay certain pre-petition taxes and assessment and granted related relief. Your Honor, I'm not aware that the debtors are in arrears or any of its obligations to its various and multiple taxing authorities, both federal and state. But the debtor needs to maintain those obligations current and pay those, some of which may cover technically some pre-petition period in the ordinary course of its business. And we seek the authorization to pay those on an interim basis as they occur and subject to entry of a final order to avoid any disruption in the operations of the debtor's business and that might otherwise jeopardize the goodwill and standing of the business in the community and its employees and customers.
Does anybody wish to be heard regarding the taxes motion? Okay, I hear no response. I note these are obligations that will shortly come due, I think, in most instances. And typically with these sorts of motions, we're talking about some of the funds may not even be property of the estate, but failure to pay these obligations as they come due could cause significant liability. So I'm satisfied, based upon the evidence before me, that the relief requested is warranted and appropriate, and I will enter the order. Again, I'm doing so on an interim basis because I find that immediate and irreparable harm would result if I did not enter the order. So it is granted.
Thank you, Your Honor. Item 10, Your Honor, is emergency motion for prohibiting utility companies from altering or discontinuing services on account of pre-petition invoices and approving deposit account as adequate assurance of payment and establish procedures for resolving requests for utility companies to additional assurance of payment, Your Honor. Fortunately, the debtor was, again, current in its payment to its utilities prior to the filing, but that means necessarily when you're current, you're necessarily, there's a period of time for pre-petition services that have not been paid. So while the debtor may have been billed for March services in April and paid that bill, it hasn't received an invoice for April that would otherwise be payable in May. And we're not asking authority per se to pay that stub period, but we are seeking authority to provide 2 weeks of security to secure post-petition services, Your Honor. And we've calculated that it's approximately $800,000. I'm sorry. It's $523,000, I assume, Your Honor, which is the average of 2 weeks services. The debtors will maintain a segregated account with those monies in that account to cover services. And we in our budget, our cash collateral budget, we have budgeted the payment of current invoices during the course of the case as and when the bills become due for the post-petition services. So we submit that the 2 weeks deposit plus the current payment of bills post-petitions will provide adequate assurances of payment subject to the procedures set forth in the requested motion.
Does anybody wish to be heard regarding the utilities motion? Okay, I hear no response. The procedures that you're proposing in the proposed order are fairly standard and universally, I think, entered in this district, and therefore I'm happy to go ahead and enter that order. Again, this is a motion seeking interim relief, and I do find that based on the evidence before me, that immediate and irreparable harm would result if I did not enter the order, so therefore I'm going to do so today on an interim basis.
Thank you, Your Honor. Agenda item 11, Your Honor, is a motion for interim and final orders authorizing but not directing debtors to pay pre-petition workforce obligations and workforce program-related obligations, continue those programs, and authorizing payments of withholding obligations and granted related reliefs. Your Honor, nothing can be more critical to the debtor's successful reorganization or even if an orderly liquidation, that it meets its obligations to its employees who are essential to maximizing the value of the state assets. And this relief, both on an interim basis and final basis, would cause, if it's not granted, would cause immediate and irreparable harm to the estate, and we'd ask the court to approve it on that basis, on an interim basis.
Does anybody wish to be heard regarding employee wages?
Oh, excuse me, I'm sorry.
Leo Munchak on behalf of Eclipse again. Your Honor, there is one paragraph we raised with debtors' counsel before the hearing, and it's regarding just blanket lift stay relief under 362D with respect to the workers' comp program. To the extent that's where the proceeds are coming from, it's only coming from the insurance proceeds. We don't have an issue. It does talk about paying off the pre-petition amounts related there too. We've asked for information as to what those pre-petition amounts, whether they're included in the budget. We're told that they're not paying the pre-petition amounts, at least for now, and we will address that in the final order. So I want to make sure that represents that fact.
That's correct, Your Honor.
Okay, thank you for those comments. Does anybody else wish to be heard regarding the wages motion? Hey, I hear no response. I'm going to grant the motion, of course. There's no doubt that this is absolutely essential, and the workers simply need to be paid. You can't run a business without it, and I can think of few orders that are as important as this one that are typically entered on the first day in a bankruptcy case. So I'm very happy to enter this order. I would note again that the Rule 6003B standard is met because I do find that immediate and irreparable harm would result if I did not enter this order. So therefore I will do so, and I will do it on an interim basis.
Thank you, Your Honor. And if I may give the podium to Ms. McLaughlin-Smith.
Good morning.
Good afternoon, Your Honor. Marcia McLaughlin-Smith of Troutman, Pepper, Hamilton, Sanders, proposed co-counsel to the debtors. I'll be presenting agenda item 12, just filed at docket number 20. This is the debtor's emergency motion for interim relief, seeking to have the store closing agreement operative and effective, as well as authorizing the store closing sales to be free and clear of liens, claims, and encumbrances. Prior to the bankruptcy, Your Honor, the debtors determined in consultation with their advisors that in order to bring extra liquidity into the estate, it made sense to retain Hilco Merchant Resources to run store closing sales with respect to 10 of the debtors' 82 stores. Pre-petition on May 5th, the debtors did enter into that store closing agreement that's attached as Exhibit A to the motion, with Hilco Merchant Resources being proposed as the debtors' exclusive agent to oversee and assist the debtors with these store closing sales. The debtors and the consultant negotiated the agreement at arm's length, and the debtors believe that the terms of the agreement are in line with industry standards. Moreover, Your Honor, the debtors and the consultants did enter into a brief amendment to the store closing agreement on May 7th, subject to this court's approval. That amendment simply clarified some additional requirements with respect to the debtors and the consultant's ability to add and remove stores from the closing sale program, as well as whether the expense budget would go up or down with that addition or subtraction of store locations, as well as clarifying some aspects of the merchant's fee on certain types of inventory. In order to effectuate these closing sales, Your Honor, the debtors also request certain related approval to the agreement. There are 4 primary categories for that. That would be relief from certain liquidation sale laws, as well as other lease or contractual restrictions that might purport to restrict the debtor's ability to run the store closing sales. And as part of that, there are also some standard proposed dispute resolution procedures between the debtors, the consultant, and governmental units. To the extent there would be an issue there, we would hopefully engage consensually with them and subject to your ability to come before you on an expedited hearing if necessary. The third is the debtor's request for relief from certain fast pay laws. Subject to a comment from the U.S. trustee, we have agreed to have this be subject to a final order only, but that relief would just allow the debtors, to the extent they were unable to pay terminated employees as of the termination date, the debtors would expeditiously as possible deliver that final check to terminated employees.
Are you able to, Ms. McLaughlin-Smith, are you able to speak to the fast pay laws that apply in each of the states where you may be doing store closing sales and you might have affected employees?
Your Honor, I can't speak today as to specific laws in each of those states. We can certainly run that down and supplement on the final basis because as you'll see in the red line, all of the fast pay relief has been changed to only on a final basis. So we can certainly pull that information together and present that for your court when this relief is sought at the final hearing.
Okay, and based on my reading, the way I'm understanding this is that if there are delays in payment based on the waiver of the fast pay laws, we're talking maybe in the order of several days. We're not talking significant delays. Is that correct?
That's correct, Your Honor. It's simply a function of whether or not the payroll system will be overloaded at the time. If all of these 10 stores close on June 30th, then there just might not be the ability to input all of the final checks, have them printed, have them sent to the stores and delivered to the employees. So we would obviously be doing that as quickly as possible, but just in case there's a day or two lag, we just would request that relief.
Okay, and for the stores that are going to be closing, do you anticipate the possibility of terminations of employees taking place on a rolling basis as stock is sold down?
Yes, the agreement does contemplate the ability of the debtors and the consultant to decide to terminate certain sale locations earlier. It's largely a product of, as exactly what Your Honor said, if the inventory and FF&E is selling quickly, whether it makes sense to end that store early and potentially reject that lease.
Okay, thank you, Ms. McLaughlin.
Yep. And then the last bucket of relief, Your Honor, is also only on a final basis, and that is the debtor's authority for a store closing bonus program. These would be bonuses paid to store-level employees, not insiders, to encourage the employees to remain with the stores throughout the duration of the sales. It would be very costly to the estates to have to hire and retrain employees for that short period of time of the sales. And that on a final basis would be capped at $163,230, a discretionary amount, but that would be the most for these 10 stores, subject to the debtor's ability in consultation with their lenders to increase that amount if additional stores were added to the sale process.
Okay. Does anybody else wish to be heard regarding the store closing agreement motion? Okay, I hear no response. I note that you described certain revisions that are going to be made based on comments received from the Office of the United States Trustee. I don't believe that I've seen the revised order, but based upon your description, I do find that, and the evidence before me, I do find that it's an appropriate exercise of the business judgment of the debtors to seek the sort of relief that you're seeking here. And it is fairly typical in this district. So based upon that evidence before me, I will enter an order granting the motion. And again, I do find that immediate and irreparable harm would result. So we're doing so on an interim basis. I have what I think is sort of an existential question for you, though. What is an interim order, really, in the context of assumption of an agreement?
So, Your Honor, this order is actually set up as an operative and effective on an interim basis. So it allows us to, I guess for this, the sales haven't even begun. So as a primary kind of step in this specific deal, the consultant hasn't been out there running these sales yet. They haven't been incurring fees that would have been related to pre-petition amounts. There was an expense deposit paid to the consultant, or I believe will be paid shortly, subject to this agreement, that will pay down their expenses as they are reimbursed pursuant to the budget attached. So that's the initial question that's kind of unique for this deal. However, it's a broader question. So on an interim basis, we would propose the relief is operative and effective, allow us to run the sales, honor the terms of the agreement, but it wouldn't be assumed officially until the final hearing.
Good, that's very helpful. I appreciate that.
And Your Honor, I do have a copy of the red line. I don't know if you would like to quickly review it.
Yeah, that would be helpful. Would you approach, please? Thank you.
And Your Honor, this is a cumulative red line against the as filed.
Thank you. Okay, thank you for providing that to me. Again, I am happy to enter this order on an interim basis, and we'll do so.
Thank you, Your Honor. We'll submit that under COC after the hearing.
Thank you.
Thank you. Your Honor, if I may, picking up on the agenda, Your Honor, is the debtor's motion for entry of authorizing the debtors to obtain post-petition financing to use cash collateral, grant liens, super priority administrative expense status, granting adequate protection to the secured lenders, modifying the automatic stay, and scheduling a final hearing. Your Honor, this has been the subject of substantial negotiations, critical again to the estate's reorganization efforts to obtain funding and use of cash collateral and secure DIP financing for the advance of additional funds. Your Honor, the order has been subject to extensive comments from the U.S. trustee. I'm not aware that there are any opposition to the allowance of the motion, and I ask the court consider entering it on an interim basis, subject to the order, which I believe has been submitted by Ms. Meltzer's office, and subject to a hearing on a final hearing. And I don't know if you would like a copy of the order that was been submitted.
We received that in chambers earlier this morning. Yeah, I did have an opportunity to review that. Okay, you done with your presentation?
Yes.
Yeah. Okay. Economical. Would anybody else care to be heard on DIP financing?
Your Honor, Liam Butcher, on behalf of Eclipse, we're going to have a comment based on the revision that was made this morning. It inadvertently omits all the debtors as being parties to the pre-petition and credit agreements. It adds the non-debtor guarantor, Christmas Tree Shops in Massachusetts, LLC, which the debtors are binding to this DIP, to the DIP order, but it ignores the debtors other than CTS. So we may have a slightly revised version we will be submitting.
Okay. Mr. Murphy, any response on that?
I'm not sure I followed all that. Just for the record, Your Honor, one debtor I think I mentioned has not been filed, which is the Christmas Tree Shops of Massachusetts, which never conducted business. It was a entity formed to acquire a liquor license and never acquired any licenses, but I'm not sure what client. Your Honor, Ms. Meltzer reports that it is apparently an oversight to. You want to take that?
Yeah. Sorry, Your Honor, it's a typo. In page 10, it should have said CTS, comma, the debtors, and Christmas Tree Shops of Massachusetts, LLC. We'll add the word the debtors in.
Very good.
For the other debtors. Thank you.
Thank you.
Subject to.
I'm sorry, Mr. Murphy.
Your Honor, I apologize.
Good morning, Your Honor. Laurel Roglin of Ballard's Bar on behalf of a number of the debtors' landlords, including Acadia Realty, which is the location up on Brandywine Plaza that your chambers is likely familiar with, Brixmore Operating Partnership, Federal Realty, and KRE Colony Owner, which own a total of 7 locations. I, of course, am also very happy to be appearing before Your Honor for the first time. We had a couple of comments to the interim DIP order that did not make it into the black line version that I believe was submitted to Your Honor this morning, but I've discussed it with the lenders in advance of the hearing once we got to court today, and I believe that they're going to be acceptable to them and will be included in a subsequent further revised order. The first of which is a revision to the proposed remedies that the DIP lenders and pre-petition lenders will be able to utilize upon an event of default, and that's adding the standard, what we consider the standard carve out from those remedies with respect to access to non-residential real property, saying that the DIP agent and DIP lender or a pre-petition agent or pre-petition lender, however those terms are defined, can only enter upon a leased premises of the debtors following a DIP termination event in accordance with either a separate written agreement among the parties, pre-existing rights under the DIP agent, pre-existing rights of the DIP agent or pre-petition agent under applicable non-bankruptcy law, written consent of the applicable landlords, or entry of a further order of this court, which would be upon notice and opportunity for the counterparty to come to court and be heard. And my understanding is that that is acceptable to the lenders and would be included in a further revised order. And that's in paragraph 3.3 of the interim order. The other change is in paragraph 5.6 of the interim order. The last sentence of that paragraph we've begun seeing in a lot of DIP orders, and it would purport to substitute or add the DIP lenders as named insurance payees on the debtors' insurance policies. And we have no issue with that, but we of course want to make sure that with respect to our owned real property, that does not in any way affect the landlord's rights to insurance proceeds on our leased premises. So we've proposed some language, some carve-outs and tweaks to that language. And again, I think that that's acceptable to the debtors' lenders. We just want to confirm that that's going to be in a further revised order, and of course that it's acceptable to the debtors as well. Thank you, Your
Ms.
Honor.
Rockland.
Oh, I'm sorry, one last thing. It's not an issue for today, but we have some outstanding questions about the sufficiency of the DIP budget. But that's not an issue for the first day hearing, as the 506C waiver and 552B waiver are not on until the final hearing. So we're going to continue to work with the debtors and the lenders to answer those questions and hopefully resolve in advance of the hearing. Otherwise, we'll come back to Your Honor at the final. Thank you.
Does anybody wish to respond to Ms. Rockland? Yeah, I hear no response. Does anybody else wish to be heard regarding DIP financing? Yeah, I hear no response. It sounds like I'll be seeing further revisions to the order, but based upon the record before me, I find that entering into this transaction is absolutely necessary for the business to be able to continue to operate during this bankruptcy case, and we hope get to a successful resolution of these cases. So therefore, I'm going to go ahead and enter the order as revised, unless there's any dispute over the terms, in which case just get me on the phone and we can work through those. I do find, of course, that the relief requested is necessary to avoid immediate irreparable harm, and therefore will enter the order on an interim basis in accordance with Rule 673B and also our local Rule 4001-2B.
Thank you, Your Honor, and I appreciate you being available. I hope we won't have to bother you with this, but Ms. Meltzer and I and her team will go back immediately to the office following this hearing, make those changes, vet it with counsel, and submit it to Chambers as soon as possible. Thank you. The last, well, it might be the last. Yes, I believe it's the last, is the motion for approval, interim and final orders authorizing the assumption. And the question is, how do you have interim assumption is one thing that we've been wrestling with, metaphysical concept. But the notion here is the consignment of goods to the estate, Your Honor. I previously mentioned that. We've characterized it variously as a critical vendor issue, in the sense that we're going to owe a little stub period for that 4 or 5 days prior to the petition for the goods we sold that we didn't own, that we're obligated to pay them. So you could call it a critical vendor. You could also call this as a financing motion, because a consignment relationship is just another vehicle for a company to purchase and obtain inventory. Or you could call it a motion to assume an executory contract. That's door number 3. And Ms. Meltzer in her office and creditors, that we've all debated on the 3 theories, and we advanced those theories with the U.S. trustee, and thankfully I think we could address their concerns. So it is critically important that we maintain this inventory flow. Mr. Salkovitz tells me it takes approximately, from the day he orders goods to go through for the consignor to purchase the goods and get to the warehouse, to get to the stores. It's about a 4-week process. So any break, goods that are coming in, we ordered 4 weeks ago, are coming in now. If we have a gap here of 3 weeks in this whole process, Your Honor, to a final hearing, that's about over $2 million of lost profits, a gross profit. So we would consider that would be immediate irreparable harm, aside from the fact that, as we say, we have holes in our SKUs. And so to give the whole panoply of the experience, we do want to fill our stores with products that are going to move quickly during the summer season, and we'd ask that be approved on an interim basis, Your Honor.
Does anybody wish to be heard regarding the consignment motion? Okay, I hear no response, and so I'm glad to see that Restore is completely on board with what you're doing here.
Thank you.
So I do find that it's an appropriate exercise of the debtor's business judgment to assume that agreement and to seek the relief that you're seeking in this motion. And therefore, I'm going to go ahead and enter the order. Again, immediate and irreparable harm would result if I did not do so. So I will be entering the order on an interim basis.
Thank you, Your Honor. I don't think the debtors have anything further today, Your Honor, and I appreciate the court's time and your staff's time this morning.
Okay, let me just confirm one thing, and maybe this is a question for Ms. Meltzer. I know that we've provided various dates, and I noticed that you filed a certification at council regarding omnibus hearing dates. So do you have everything you need in terms of dates and the court's availability?
Yes, we do, Your Honor. We're planning to have the second days on May 31st. We have a hearing June 15th that will be retention applications, interim comp, and anything else that needs to get filed between now and then. July 7th is our targeted date for our disclosure statement hearing, and August 15th is our targeted date for our confirmation hearing. So we thank the court very much for giving us those dates now so that we can work towards those goals in a very quick time frame, as Mr. Murphy explained.
Okay, thank you. I appreciate the quality of the presentations today, and I especially appreciate the helpfulness of Debtors Council's communications with Chambers about things like scheduling and the progress of the revised orders. Is very helpful to the court.
No, and thank you, Your Honor, to your staff. I mean, we kept in touch with them Friday night, over the weekend, and the past couple of days, so we greatly appreciate that. Thank you very much, Your Honor.
Thank you. Does anybody else wish to be heard? Okay. Well, I wish everyone a good day, and we are adjourned.
Thank you, Your Honor.